Okay, so welcome everyone, and tonight we're going to be dealing with a topic on natural justice. And I wish to begin by thanking Michael, Karine, and Harry for joining tonight's session. And as we go through this particular topic, it's one that is something that's really relevant for a lot of people, mainly because you would like to know if a decision is going to be made by an administrative decision maker. You'd like to know, first of all, if they're actually permitted to give you a chance to, hear your side or provide evidence in your behalf, if you should be permitted to provide evidence in your behalf, before they make a decision that may be adverse to you. So, for example, let's assume that you're involved in a child custody dispute, so meaning involving perhaps questions of child support. And let's assume that your ex-spouse or your spouse is applying for child support. You'd like to know if the child support agency is just going to suddenly ask your employer to set aside part of your income for the purpose of paying child support. Or do you suppose that there's actually a requirement for the child support agency to at least provide you an opportunity to contest any application for child support made by your ex-wife for the purpose of you providing evidence about custody arrangements, whether or not there might be court orders in place? You'd also like to know, in relation to the principle of natural justice, as to whether or not there's actually a requirement that every time a decision is made by an executive decision maker, they must always provide you, as a person who could be affected, an opportunity to be heard. So it could be questions like, let's assume that at the level of maybe the Queensland government, if they decide, for example, to increase license fees, whether it's about license fees for cars or for maybe business licenses and so on, would there be a requirement that there has to be a hearing which would give citizens an opportunity to question a decision made by the government pertaining to the amount of taxes or license fees that they will impose? And in those instances as well, where you apply, for example, for work, and let's assume that you had a very good opportunity, you think, to be hired, mainly because the selection criteria for a position, such as in the government, really is something that your own qualifications either easily meet or surpass. And if a decision is made that where you do not become the person chosen, does it mean that you can actually say that your right to natural justice may have been breached because you were never given an opportunity to be heard? And does it follow, therefore, that if someone working, for example, with the executive had his or her employment terminated, would that also mean that there is a requirement that there must be prior notice before your employment would be terminated? That's one aspect of natural justice, and that's a question of whether or not there is a right to a prior hearing before a decision is made against you. And we're going to examine that in greater detail in a short while. The second aspect is, let's assume that you've applied for particular funding, for example, or you've made an application with an executive, but you know that the executive has in the past made public statements that were adverse to the kind of position you're adopting. Does it mean, therefore, that there would be a breach of natural justice if the executive seems to harbor particular inclinations about the subject of your application? Meaning, can you say that because on the basis of public statements made by an executive, there appears to be a bias in the way that he thinks, so that that person shouldn't be making a decision at all? And it could be a question of applications, for example, for visa. And we will recall that when Peter Dutton was the Minister for Home Affairs, and particularly the Minister for Immigration, he had made statements in the past where he was quite averse to the idea of just granting individuals a right to citizenship or a right to permanent residence in Australia. And So therefore, if a person were to apply for permanent residence or even apply for citizenship, therefore, and the decision would eventually be against that application, can it be said that that there was a denial of the right of natural justice on the basis of the fact that the minister had at some time made public statements against the idea of quickly granting visas? And would there be a distinction between public statements made by a minister as opposed to an executive functionary, meaning a career officer who is not really part of the Commonwealth Parliament, in terms of being able to make public statements? So this is the idea of the principle of natural justice that we would like to delve into, because in all likelihood, in many instances, there will be opportunities where we feel that we were not given an opportunity to be heard by the executive. And it could be as simple as, how about those instances when, although this is going to be at the level of the Queensland government, for example, when when you park your car on the street, it could be the Brisbane City Council, and the Brisbane City Council just sends you an infringement notice because you parked your car illegally. Would there be a breach of natural justice in that instance? Because you park your car, they sent you an infringement notice without giving you an opportunity to contest that you were actually parking legally. It could also be questions of, you seem to have, and in the case of the Queensland state, you could have potentially exceeded the speed limits, and you have one of those traffic vans which automatically capture instances when cars may overspeed, and then you are sent an infringement notice. Was that a breach of the principles of natural justice, where you all of a sudden you get an infringement notice without it really being asked whether or not you in fact violated the traffic rules? So these all go to that issue of principles of natural justice, and therefore it is a topic that everyone should be aware of, because oftentimes you will even hear it in the media, there is a breach of natural justice and so on. So it's a topic that is really relevant to a lot of people. So tonight, after studying this topic, you should be able to discuss and explain the principle of natural justice and when it applies, and in relation to the principle of natural justice, how different is it from the principle of procedural fairness? Are they one and the same? And why is it that there are certain justices of the High Court who believe that the idea of the principle of natural justice as a concept is not the preferred concept, but it should be the principle of procedural fairness? Why is that? What's the difference there? So we'll try to get into that in today's tutorial. And then after studying this topic, you should be able to discuss and explain the hearing rule and the rule against bias. Now, before we start talking about tonight's topic, I wanted to know if any of you might have a question, whether in relation to this topic or topics in the past, or even in relation to the midterm written presentation assessment. And I'm hoping that you would have received the email I sent out last night about the midterm written assessment, which would already be due on Wednesday of next week. Will there be any questions or comments in the meantime before we discuss tonight's topic? Questions, comments?
Sorry, was the email sent to CQU email address or?
I wouldn't know, because it's an automated email I did. So I just went to the compose new email, which is in Moodle, and whatever is the default setting you've set, your default email within the system, you will get a copy of the email. Now, in the event, Karina, that somehow you did not get an email last night, you could actually just go back to Moodle, and right below my signature line, you will be able to download a copy of the midterm written assessment, as well as a copy of the marking rubric, in case you failed to get it last night. It's just there in Moodle, and you have 1 week anyway to submit the assessment.
Okay, thank you.
Okay. Comments, questions? Let's proceed. Now, as we often do, before we start talking about the topic and going through the discussion questions, I often touch upon the quiz, mainly because, again, going through the quiz gives us an opportunity to kind of put our minds around the topic for the week, and of course, in a sense, guide you in terms of answering the quiz, so that if you do the quiz correctly, you end up with 1 point, and that 1 point can be really crucial later on in terms of you getting a high distinction, a credit, or a pass, and so on. So we're going to go through the quiz, not so much for me to provide an answer, but just for me to maybe identify the legal issue for you, because what we often do in the succeeding tutorials will be to practice doing what is known as the IREC format of answering case type questions. So it's about identifying, so if you're confronted with a case type problem, you need to be able to identify the legal issue, because the legal issue is crucial in delimiting the kind of rules that you should identify. Because of course there are so many rules, even in terms of administrative law. There are relevant rules every week, and certainly in the entire term, there are many rules and principles about administrative law that you encounter. So the question is, if you're confronted with a case type problem, what particular rules should you identify and state, in an answer? And of course, the answer to that question is that it all depends on what the legal issue is. If this is the legal issue, if you define it correctly and narrowly, then you should be able to clearly articulate what the legal rules are. Because the moment you then are able to identify the rules, so after you identify the legal issue, the moment you've stated what the legal rules are, all you need then to do, following the IREC format, is to apply the rules to the facts. So if you were to apply the rules to the facts, what does that tell you? It then provides you an opportunity to arrive at a well-reasoned conclusion or well-argued conclusion. So we're going to do that. Now, can I ask someone to just go through, read through the quiz question for us? Michael? Yes, please.
Applied for a scholarship under the Research Development Scholarship Act administered by the Australian Department of Education. The Act provides that research development scholarships shall be awarded on the basis of academic merit. It also provides that the Minister of Education shall head the RDS selection committee. Shall head the RDS selection committee. Having graduated with first-class honours from the University of New South Wales, Gail was confident that she would get a research development scholarship. However, she had some apprehension about getting a scholarship because the minister had shown during a TV interview a bias against students who protested against the visit of the Chinese Premier in Canberra, during which a major student disturbance had taken place. Gail had led the student protest during the Chinese Premier's visit and had even engaged in a heated shouting match with the minister at that time. Gail subsequently received a brief letter informing her that her scholarship application had been unsuccessful. No reason was provided for the rejection of her scholarship application. Gail has come to you, her solicitor, for advice. Mute.
Is that only me can't hear the conversation?
Yeah, no, we're
sorry, sorry, I muted myself. Okay, I muted myself. So let me repeat that. Thank you, Karina, for pointing that out. So let's assume, put yourself in the position of Gail. So this is always one way of appreciating a case type problem. Imagine that you're Gail, and imagine that you feel like you're really in a position to get one of the scholarships, because let's assume that there are many scholarships that are being offered by this particular act. And so, you could be, you have a very high chance of getting a scholarship. And yet your problem is that the person who is heading the committee that hands out the scholarships and reviews scholarships application is somebody who has, with whom you've had a problem before, such as a student disturbance. And you wonder if that particular minister would now have a bias against you, and which would therefore affect your chances of getting a scholarship. So think about that. Now, in terms of the quiz, these are the potential answers. And Michael, do you mind going through the potential answers in the quiz for us?
Yes, so which of the statements is most correct? Gail's right to natural justice has been breached. She should have been given an opportunity to explain her role in the student protests prior to her scholarship application being rejected. Or Gail's right to natural justice has been breached. The minister showed a bias against her. Or as part of her right to natural justice, Gail has the right to demand reasons from the minister for the rejection of her scholarship application. Or Gail has no right to demand reasons from the minister for the rejection of her scholarship application. Or Gail's right to natural justice was breached by the failure of the letter to provide reasons for the rejection of her scholarship application.
Okay, thank you, Michael. So if we go back to this particular question, and of course, as far as the quiz goes, we've kind of limited what the answers should be. What exactly would have been the legal issue here? Can you make a guess, or can you attempt an answer? What do you suppose is the legal issue as far as this problem is concerned?
Has Gail's natural justice has been breached by not being provided with explanation for unsuccessful application?
Okay, that's one. Very good. What is the other one? So go on.
Sorry, is it minister who made a decision?
Yes, it was the minister.
Yeah, minister. So was the minister biased against the Gail?
Very good. So, very good. So, in this particular, under the case facts, the legal issue as correctly identified by Corina is whether or not the right of Gail to natural justice may have been breached, one, because the minister may have shown a bias towards her or against her, and two, whether or not her right to natural justice was breached by the failure of the minister to provide a reason for the rejection of her scholarship application. So if we therefore define the legal issue that way, it leads us to try to identify what exactly is the rule on natural justice. What is the rule of natural justice in relation to the question of bias? And what is the rule of natural justice in relation to the need to provide reasons for a decision by the executive? Okay, so they're very good. Well done. Now, am I in a position to provide an answer here? What do we know the rule to be as far as the principle of natural justice is concerned? Without me providing an answer, what do we recall about the principle of natural justice?
There's two parts.
Very good.
One is the higher prior hearing rule,
Yeah.
and the other one is the no bias rule.
Very good. So let's talk about the prior hearing rule. In relation to the prior hearing rule as part of the principle of natural justice, we know what prior hearing rule is. Before a decision is made, you ought to be given an opportunity to be heard. And we're going to have to clarify, does that apply in all cases? Or does it mean that you do not always have a right to be given an opportunity to be heard? The example I had was when you get an infringement notice. Would it be a violation of the right to the prior hearing rule if you were just given an infringement notice without you being given a chance to contest an assertion that you had violated some traffic rules? Or if you had applied for a job and before your application could be rejected, let's say by the Commonwealth, does it mean that the Commonwealth must tell you, please, please give us, further evidence so that we will not reject your application? What exactly is the prior hearing rule? Does it apply in all circumstances? That's one. Does it also mean that in relation to the prior hearing rule, if a decision is made against a person, especially in those instances when the right to natural justice actually is to be recognized, does it require the executive to provide reasons for a decision? Are they one and the same? So is there a requirement as part of the prior hearing rule that an executive must provide reasons for a decision? That's one. Secondly, what exactly hello Clinton, thanks for joining us. Secondly, in relation to the question of a lack of bias, so that no one should be a judge of his own cause, as it is traditionally stated, what exactly does the no bias rule mean? Does it mean that if a minister, for example, makes public statements that he is against student protesters, does that public statement necessarily disqualify that minister from making decisions later on that may affect a particular person on the assumption that that minister is necessarily biased? So those are the two relevant questions there. We're not going to be able, we're going to leave it for now. And we will notice that when we go through the 4 discussion questions tonight, you will have a better idea on how to answer this particular question. But we're not going to address that directly for now, because otherwise I'll be providing the answer. But as we go through the 4 discussion questions, it should be clear to you what the answer here is. And if it isn't, call my attention before we end tonight's tutorial. Okay, so we're going to leave that for now. Questions so far? None? Let's begin with problem 1. Can I ask one of you to read problem 1 for us?
I can read.
Go on. Thank you, Corina.
The Business Regulations and Control Act Commonwealth requires that before a person or persons may engage in business or a commercial activity, prior to registration must be secured from Australian Business Regulatory Agency. The Act provides that the agency has the power to shut down a busy or commercial activity that operates without being registered with it. In addition, the agency may also seize documents, papers, goods, properties, and assets belonging to an unregistered business and impose a fine. The Act is silent on whether prior notice must be given by the agency before seizing the documents, papers, goods, properties, and assets belonging to the unregistered business. Aaron Lamb had been operating a small business for some time by selling his handmade goods to customers online. However, he failed to register the Australian Business Regulatory Agency. In February, representatives of the Australian Business Regulatory Agency came to his house without notice and seized the goods, documents, and papers. They informed Lamb that his goods, documents, and papers would only be returned after he paid a fine of $10,000. Lamb has come to you as a solicitor for advice. Advise Lamb on the validity or invalidity of actions of the agency.
Thank you, Corina. So we will notice here from the facts that the representatives of the Australian Business Regulatory Agency had come to the house of Lamb. Okay, let's be clear about that. And we recall, if we recall the idea of the principle of legality, we know that it is a recognized right in common law that people's homes are their castle. And the executive, if they are to enter anyone's home, they must do so on the basis of a statutory authority. They cannot claim an inherent executive power to just freely enter into a house. And so we know that as a fact. So here in this instance, based on the case facts, it would appear that, without giving any notice to Lamb, representatives of the Australian Business Regulatory Agency just came to his house without notice and seized his documents, goods, and papers. Let's begin by identifying what the legal issue is. What is the legal issue here?
Does the agency have
Go on.
authority? Does the agency have authority to seize documents, papers, goods, and properties and assets of an unregistered business?
Okay. Now remember, what we do in this instance is to, as an informative session, I'm going to provide some comments to, propose answers for the purpose of learning. Okay. Now, what we need to remember is that when we try to identify the legal issue, our goal is that by identifying the legal issue, we can then state what the legal principles are or the relevant legal rules are. So what it means is that the legal issue as identified should not have to be answered by looking at the facts again. The legal issue should lead to us identifying legal principles. So if the question is, does the agency have the authority? That seems to be a factual question, because then what we need to do is to simply look at the Business Regulations and Control Act. And then we say the agency has the authority under the Act, or the agency does not have the authority under the Act. So I would suggest that when we identify the legal issue, identify it in terms of leading to the identification of a particular legal rule or principle. And in this case, try to couch your identification of the legal issue in terms of natural justice. Can we do another attempt?
Has Australian Business Regulatory Agency breached natural justice against Mr. Lam?
By
not giving notice and entering his house and taking the goods, documents, and papers from him.
Very good. I would like that. Would you agree that that seems to be, a good way of identifying the legal issue? Can you repeat that, Karina?
Yeah. I was just wondering about that $10,000.
Can you just repeat the way you formulated the legal issue for us?
Australian Business Regulatory Agency breached natural justice against Mr. Lam because they did not give notice and came to his house without warrant, I guess, and taking goods and documents and papers from him.
Very good. So if we look at that as the legal issue, and I like that, what it suggests is we need to know what exactly is the rule of natural justice, especially in relation to what Karina said, is whether or not before, the representatives of the agency, should they have, before they enter the house, should they have provided notice? And should they have also provided notice before they seize the documents? That was the legal issue as identified by the Karina, which means we then need to identify what the relevant legal rules are. Very good. So Karina, you wanted to say something?
No, I'm just listening.
Okay.
Yeah, I'll make a comment later.
That is the legal issue. I like it. So we know it's about natural justice. It's about lack of notice before somebody entered the house and seized papers. What do we know to be the legal rule in relation to that particular legal issue? In particular, in relation to natural justice and notice and deprivation of goods and entering homes. What do we know the rule is in relation to natural justice?
It's prior hearing rule.
Go on. Yes, go on. So what does it mean?
They didn't give opportunity for Mr. Lam to defend himself or make a case for himself before making decisions.
Okay, so that's a fact. That seems to be a fact. But what is the legal rule?
Must give opportunity to make case for themselves before making decision, or give a proper opportunity to respond to the action, or
so in all instances?
Not in all instances, but there are some exclusions of natural justice. But
when does the right to natural justice arise? What exactly is the right to natural justice?
When his rights, like for his goods and documents and papers are taken, he owns those things, and it's.
So let me change the facts a bit, okay? Let me just change the facts a bit. Let's assume that the facts are exactly the same, but in this case, what Lam has done is that he's operating from a building, from a commercial area, without any license, without any authority from the Australian Business Regulatory Agency, and the ABR representatives just entered the property without notice, the commercial property without notice, to seize his goods, documents, and papers. So the factual scenario based on problem 1 is that the agents entered his house without notice and seized his goods. Would it be different if the agents entered a commercial property, not a house, but a commercial property without notice to seize documents, papers, and goods? Are they one and the same? What has, these two kinds of factual scenarios have to do with the principle of natural justice? So what exactly is the principle of natural justice? So as a reminder, when you speak of the principle of natural justice, what the rule is that before the executive can breach or interfere with or intrude into the rights, interests, or legitimate expectations of a person, that person must have been given an opportunity to be heard. So the requirement that a person must be given an opportunity to be heard only arises when that person has a right, an interest, or a legitimate expectation that shouldn't be breached by the executive. So in other words, if a person has no right, if a person has no interest or has no legitimate expectation, the executive is not required to provide prior notice or a right to be heard. Are we clear about that?
Well, what happens if Mr. Lam let them in?
Oh, that's something else. That is something else. Okay.
Yeah, he didn't know. It is true that, and also the act is silent on whether prior notice must be given by the act.
Good. And let's assume that the act is in fact silent on whether or not notice should be given.
Okay, so even though it was a silent, it is implied duty to the agency that they will act in accordance with the natural justice. They will uphold the natural justice.
So that's the question there. Assuming we have that kind of assumption, especially because we have the principle of legality, the question is, in this particular instance, would there be a difference between representatives of the agency entering a house without notice and seizing goods and entering an office without notice and seizing goods? Are they one and the same?
No.
Why is that? Very good. Go on. Let me just answer that. They're not the same because we know in terms of the common law that there is a common law right against anyone, just against the executive, just entering into a house without express statutory authorization. Okay? So a person has a common law right not to have his home entered into or invaded by the executive without prior notice and without an express authorization from a statute. So there is such a right. Are we clear? And so because there is such a right, a common law right against, we studied this on the basis of the principle of legality, because there is a common law right not to have one's home invaded by the executive without proper statutory authorization, it also tells us that before the executive can enter one's house, under ordinary circumstances, there must be prior notice because one has a right. Okay? So in the example, therefore, the answer would be that there would be a breach of the right to natural justice on the part of Lam because of his recognized common right not to have his house invaded by the executive without express statutory authorization. So there is a breach. On the other hand, if the scenario had been, in the second scenario I gave, if the scenario had been that the executive or the representatives of the agency entered a commercial property for the purpose, without notice, for the purpose of seizing goods because there is a violation of the law, there is no common law right against an invasion of a commercial property. Are we clear with the distinction there? So let me restate the principle of natural justice. The principle of natural justice states that a person that the executive must not interfere, breach, or intrude or infringe upon the rights, interests, or legitimate expectations of a person without giving that person an opportunity to be heard. So the opportunity to be heard only arises when a person has a right or has an interest or a legitimate expectation that must be observed and respected by the executive. Where there is no right, you cannot speak of a right to be heard in the first place. Will that be clear? So, for example, if you apply for a job with the executive, because there's a job that has been advertised, and as it would usually happen, a lot of us, so assuming there's only one position, there are maybe 50 who apply. Those who are unsuccessful in the application, of 49 of them, are not going to be asked by the executive to provide reasons why their application should be rejected. What will simply happen is that the executive will send them a letter, sorry, application has been successful and has been unsuccessful. So the question for us is, by not providing us an opportunity to explain why our application shouldn't be rejected, was there a breach of natural justice? The answer is no, because no one has a right to be hired. It is not a right to be hired. And you cannot have a legitimate expectation that you will get hired. And you certainly do not have an interest, a legal interest, that you can say, therefore, that you have a natural right to be hired. It doesn't exist. Are we clear there? Questions?
I just wanted to ask you just a quick thing.
Go ahead.
Maybe I'm just being pedantic, but it's
Yep.
It says the agency may also seize documents, papers, goods, and properties and assets.
Yes.
It does not say they may enter the premise, though.
Yes, that's right.
So even if it's a commercial property, they may still need a warrant to enter the property.
That's your argument.
Yes.
The question is why?
Is that silly?
No. The question is why?
Because the law does not provide for them to enter the premise, even though they are regulating the commercial businesses. The Act only says seize documents, papers, goods, and properties and assets. It does not say they can enter the premise.
That's the way a lawyer thinks, Karina. Very good. The distinction we make, however, that's a very good point, Karina. The distinction, however, we make is that more than the provisions under the Act, the question is, what is the right of a person? We know that there is a common right against the executives entering the house of a person without express authorization. There is that common law right. But there is no common law right that a person's office cannot be entered by the executive without proper or without express authorization. That right, there is no such there is no common law right in that regard. Okay, so if you look at the common law, there is a statement there that every man's home is his castle. And for that reason, even the king's men stepping on the grass is an invasion of property. There is no equivalent legal principle in terms of an office, because a man's office is certainly not his castle, and it is not his home. And so therefore, in relation to the right of natural justice here, the specific right of LAM in this regard is really in relation to his right not to have his house invaded by the executive without express authorization from a statute. Okay, are we clear about that? So LAM has a common law right not to have his house invaded by the executive without express statutory authorization. However, a person cannot say that he has a common law right not to have his office invaded without express statutory authorization. That common law right does not exist. There is no such common law right. So there is the distinction there. Did that clarify the point you raised, Karina?
Yes, yes.
Okay, very good.
Thank you.
Okay, well done. So I like that kind of argument, Karina. Well done. Problem 2. Can we get somebody to read problem 2 for us?
I'll read it.
Thank you.
During a TV interview with James Colt for the televised Colt Report, Minister for Immigration and Border Protection, Scott Tomlinson, said, "As the Minister for Immigration and Border Protection, I have very strong reservations about people applying for Australian resident visas who claim to have an epiphany and claim to be good and honourable men, despite having committed serious crimes and atrocities in the past as jihadi fighters abroad. These people are heavily radicalised by their war experiences and pose a potential danger to our community, even if they may appear respectable today by running a string of businesses in Sydney or elsewhere." About a month after the TV interview, Omar Awaldi, who owns a profitable chain of laundromats in Sydney, received a letter from a delegate of the minister informing him that his application for an Australian permanent visa had been denied on account of evidence that he had committed serious crimes and atrocities in the past as a jihadi fighter abroad. Oop. Something's happened to the screen.
Oh, is it there?
Up, now it's gone.
Okay.
The letter stated further that notwithstanding the character references and evidence presented by Awaldi that he was a changed man, the minister was of the view that Awaldi is an excluded person under the Migration Act 1958. Awaldi has come to you for advice as a solicitor and believes that the minister was biased against him. Advise Awaldi if the minister's decision may have been affected by an actual bias as shown by his TV statements, and whether there may have been a breach of natural justice.
Very good. So thank you, Michael. So it's the potential claim that Awaldi's right to natural justice may have been breached is because of certain statements made previously by the minister, which tends to show a bias or perhaps a prejudgment about individuals who have the same character or the same attributes as Awaldi, which leads us to the question, what exactly is bias? So what do you suppose is the legal issue here? So in a televised Colt report, so the minister had made statements, okay? So in other words, do those statements reflect a bias towards applications of individuals who may have been jihadi fighters abroad or are alleged to have been jihadi fighters abroad? So that since the minister has made that kind of, public statement, does it therefore mean that he shouldn't, because of that particular bias or even an apprehended bias, there would be a breach of natural justice if the minister were to then make decisions that involve people of this nature? What exactly does the rule about apprehended bias or even actual bias mean? So let's identify the legal issue. What is the legal issue here?
Has bias rule been breached by Immigration Department?
Because why? So okay, that's a good start. Why do we say that the bias rule seems to have been breached? So we need to connect that. Why?
Because of the minister's comment on TV.
What about the comments?
That the jihadi, he expressed that
That's going back to the
crimes. Yeah, he talked about the jihadi fighters abroad.
Try to draw, Karina, a principle behind it. So when you characterize the statements of the minister, what does it tell you? So he made public statements, but what is the nature of the public statements? How would you describe those public statements?
Personal view. I don't know.
Yeah, okay, but there's nothing wrong about personal views. What about it?
His personal view may have affected the decision of the department.
Okay, go on. Yeah, we're getting there. We're getting there. What is it about the minister's statements that can be a cause for concern? They show maybe hostility. They show prejudgment. Would that be it? Hostility and prejudgment can be said to demonstrate bias, wouldn't they?
Yes.
If you're hostile to me, if you make statements that are hostile to me, accuse me of things, or seem to prejudge me, I would say you're being biased. So if we say that, therefore, how should we then try to identify or state the legal issue?
Has the minister's view on jihadi fighters abroad, past the jihadi fighters abroad, impacted on the decision to decline the permanent visa for Mr. Owaldi?
That's a factual question. It doesn't tell me what rules we should be talking about. You didn't even talk about natural justice. You didn't talk about bias.
Yeah, natural justice.
Okay. I would suggest that would anyone want to attempt to state the legal issue here? Michael?
Well, has the minister breached the rules of natural justice by making comments concerning the past atrocities of jihadi fighters, which has demonstrated a propensity for bias?
Very good. So we're getting there. Okay. So the minister's statements, whether there was a breach of natural justice because the minister's statements showed some bias. Very good. So if that is the legal issue, we can now talk about natural justice. We can now talk about public statements as demonstrating bias. Okay. So if I were to repeat what Michael said, if I remember it correctly, Michael was saying that the legal issue is whether or not the minister may have breached the rights of Owaldi to natural justice by making public statements that seems to have demonstrated a bias against him or people of, or people like him. Would that be good enough? The type of legal issue? So we talked about natural justice, we talked about public statements, we talked about bias.
Yeah.
Okay. So if we agree that that's a better statement of the legal issue, what are the relevant legal rules here?
Well, you'd have to define then what is bias.
Okay, before we talk about bias, we define what natural justice is. Okay. What is the rule of natural justice?
Well, that every person should be heard in relation to decisions that are being made in relation to them.
That's too broad. There were 3 instances when you said the right to natural justice arises. What were those 3?
So should Mr. Owaldi have been given prior notice before department making decision?
Okay, but let's talk about the right to natural justice. When does somebody say that he has a right to natural justice? When does the right to natural justice arise?
When there is a right, but Mr. Owaldi's permanent residency visa, well, the right, there isn't really a right to be granted for.
That's right, that's correct. There is no right. Does he have a legitimate expectation, though, that when he applies for a visa, his visa application should be reviewed dispassionately and without bias? Can that be a legitimate expectation?
But what is the evidence of being biased, though?
Hang on. That's the evidence of bias is something else. Let's just talk for now, because there are 2 aspects we talked about, remember? The legal issue said, right of natural justice in relation to bias. Let's talk about, because if there is no right to natural justice, we don't even have to talk about bias. So is there potentially a right to natural justice on the part of Owaldi? You had said correctly, Karina, he doesn't have a right to be granted a visa. I agree with that. Does he have a legitimate expectation that his visa application will be considered by an executive who does not have any bias? Can there be a legitimate expectation?
There will be legitimate expectation, but there are a lot of other factors the department need to consider before they make decisions.
Yeah, but I mean, we will have to agree that when you apply for something, in this particular case, everyone will have to assume that you have a legitimate expectation. You will be treated fairly.
Yes.
You have a legitimate expectation to be, to have your application examined or reviewed by somebody who is fair. Imagine if you don't have that legitimate expectation. Can you have a legitimate expectation that somebody there evaluating your application is actually biased? That can't be done. So we will assume that Uvalde in this instance, or any applicant for a visa, has a legitimate expectation that the person reviewing the application cannot be biased. Okay, so we will agree on that. There is a legitimate expectation. Now the question, however, now is, if Uvalde has a right to natural justice, in the sense that he has a legitimate expectation to have his application reviewed by an unbiased and a fair and objective executive, would it mean, therefore, that the public statements of Uvalde demonstrate a bias that should disqualify him from making a decision in relation to the application, because that would be a breach of natural justice? So what is the rule now in relation to bias? So does it mean that the minister cannot make a public statement concerning, because it's making a general and broad policy statement, it would seem. Does that mean that that is a disqualifying bias? That he shouldn't be allowed, therefore, to make a decision? Okay, so,
well,
yes, go on.
As you've highlighted in red,
yes,
you just said, I have very strong reservations.
Yes.
Therefore, he didn't say that just because someone is a returned jihadi fighter abroad, I'm going to exclude them.
Very good.
So that's basically a get out of jail free card.
Very good. Very good.
He was merely making a political statement rather than an opinion.
Fantastic. That is, in fact, the rule. In Minister for Immigration and Multicultural Affairs versus GIA, the High Court had said that ministers, because of the political nature of their office, typically make public statements concerning policy, which may be in favor of or against certain persons. And so, therefore, they may show some kind of bias, but that is not a bias that would disqualify him. The disqualifying bias is a state of mind that is incapable of being changed. It is a prejudgment of an issue that no matter what the evidence is, that particular executive will always adhere to a particular position, and he couldn't be swayed by any amount of evidence that is presented. That is a disqualifying bias. But for as long as there is a proclivity only, an inclination towards a particular position, for as long as there is just a prejudgment, but that prejudgment can in fact be changed according to the evidence that is presented, that is not disqualifying bias. Okay, so a disqualifying bias is only one where the state of mind is so closed, is so committed to a particular position that it is incapable of alteration. Only then can you say that there is a disqualifying bias. And the case for that is Minister for Immigration and Multicultural Affairs versus GIA. And it also suggests to us that ministers, because of the political nature of their office, are actually permitted, and it's part of the democracy that we live in. The ministers can make public statements in relation to particular policies. And the mere fact that they make statements in favor of against certain persons or in favor of against certain positions is merely a prejudgment, but it doesn't mean that those ministers will in all instances stick with that prejudgment regardless of whatever the evidence may be. It's just a public statement they're making. Okay, so in this case, having identified what the legal issue was and having identified what the relevant rules are, if I were approached as a solicitor, I would advise Uvalde that although he has a right to natural justice, a legitimate expectation to have his application reviewed by an executive who does not have a bias, the mere fact that the minister has made kind of a prejudging statement in public does not mean that his position is actually unalterable according to the evidence. So if you follow the case of Minister for Immigration and Multicultural Affairs versus GIA, the public statements of the minister do not indicate that his prejudgment is incapable of alteration. And therefore, there can be no breach of the right to natural justice on the basis of any apprehended bias in this particular case. Questions, comments before we move on to the third one? We're good. We've only got 4 minutes to go. Are you free to hang on or what?
Yeah, because I can hang on.
Okay, very good. So because we've got 2 other questions, should we go through questions 3 and 4? Are you happy to do that? Okay, very good. Okay, so let's look at problem 3. Can somebody read the question for us?
I'll read it for you.
Thank you, Karina.
Clamshell Star Proprietary Limited is an online retailer of imported electronic gadgets and toys, operating since 2014 under an annual renewal business license issued by the Australian Business Regulatory Agency, ABRA. In December 2017, it received a notice from ABRA that its application for renewal of business license had been rejected on the ground that some of its imported products had been the subject of complaints from consumers for being faulty. The Business Regulations and Control Act, Commonwealth, requires that before a person or persons may engage in business or a commercial activity, it must first secure a business license from ABRA, which has the discretion to grant the license as it sees fit. The Act provides that the agency has the power to shut down a business or commercial activity that operates without a license. In addition, the agency may also seize documents, papers, goods, properties, and assets belonging to an unregistered business and impose a fine. Clamshell Star Pty Ltd comes to you as a solicitor for advice and give advice it on the validity of or invalidity of the actions of the agency.
Very good. Thank you, Karina. So I just wish to highlight what is in the facts. So the facts here talk about an application for renewal of business license. Renewal. So there is an existing license. It wants to be renewed. It is not the same as an application for a license where there is no license yet. So there is a license so Clamshell possesses a license. It wants it renewed now. So that is the nature of the facts. I want to draw that distinction, and then I'll explain why in a short while. What is the legal issue here?
Is the agency's actions is the agency's action invalid?
Okay, but if that is the statement, what legal principles are we going to be citing? It's too broad. Why can it be invalid? Why can it potentially be invalid, Karina? By
natural justice.
Okay,
Has
go on.
natural justice being breached?
Why? Well, why is the right to natural justice potentially breached? Why?
There seem to be no procedural fairness, and there is no the prior hearing rule doesn't seem to be upheld.
Still too broad. Okay. Michael, did you want to say something?
I was going along the similar lines. So, has natural justice been breached by the agency in that it has failed to provide the business with an appropriate hearing prior to rejecting the renewal application for the license?
Very good. Okay, so this is recorded. I'm not going to, that's 100%. I would give that, perfect scores if that was the way that the legal issues was stated. Well done. So Michael talked about the right to natural justice. He talked about the failure to provide a right to be heard on the part of Clemshaw in relation to the application for a renewal of business license. Renewal of business license. Are we clear? Fantastic. What is the rule?
Well, I guess we come back to the hearing rule again.
Very good. Okay, what is the hearing rule?
Where the person has rights, interests, and a legitimate expectation that their license that they have is going to be renewed.
Very good.
Have they received natural justice in that rejection?
Very good. Because they were not heard. They were not given an opportunity to be heard before the rejection. We're talking of renewal. What is the rule here? So in the case of FAI Insurances Limited versus Winiki, the High Court said that when there is an application for renewal of a license, that person applying for renewal has a legitimate expectation that the license will be renewed. Okay, so there is a recognized right, a recognized right to natural justice, or a legitimate expectation that when one applies for a renewal of a license, that license will be renewed. That's the case of FAI Insurances Limited versus Winiki. Are we clear? Renewal. So if that is the rule, what's your conclusion? How do you apply the rule to the facts?
Well, the facts are that they haven't been informed previously that there have been complaints about the quality of their products.
Very good.
So therefore, they haven't been able to fix the issue.
Okay.
They haven't been able to respond to the complaints.
You haven't. Okay. Try to connect that statement, Michael, in relation to the rules you just stated. So tell us something about, the renewal of the license, the right to be heard before a renewal license application is rejected. Say something about that.
Is that LAWS v ABC or something or other? Where
so we've already stated you've already stated the rule earlier, Michael, that a person has applied for renewal of license. That person has a legitimate expectation that the license will be renewed, and that if the license were not to be renewed, that person must be given an opportunity to be heard. That's the case of FAI Insurances Limited versus Winiki. If that is the rule, apply the rule now to the facts. Okay, under the facts.
Well, under the facts, then Clemshaw Star Proprietary Limited is applying for a renewal of their business license.
Go on.
They therefore have a legitimate expectation then that their license will be renewed.
Very good.
And if there is any concern regarding the renewal of that license, then it's expected that there would be a hearing prior to a decision being made.
And what has happened here?
A decision has been made without any hearing, without any submissions being requested by the regulatory agency.
And therefore, in conclusion, as a conclusion?
And therefore, they are in breach of natural justice.
Fantastic. That's the kind of answer I'd like to see.
Right.
That's a high distinction answer. Well done. Fantastic. So we now, so what advice are you going to be giving to Clemshaw?
Then they would then be able to apply for judicial review because the decision's been made under the Act.
So it was in breach of the rules of natural justice.
Yeah.
Very good. Fantastic. Are we clear? So we're done. Okay, we're done with problem 3. Pay attention, please. I'm going to change the facts a bit. Pay attention because this particular point will be relevant for the final assessment. Okay, are we clear? It's a hint. Relevant for the final assessment. So I want to be clear. I'm changing the facts a bit. Okay. Let's assume that Clemshaw Star applies for a license for the first time. Not a renewal, applies for a license the first time. When it applies for a license, the license application was rejected without giving Clemshaw an opportunity to be heard. Remember, this is new facts, okay? We'll call it problem 4. Let's assume that Clemshaw applied for a license for the first time, its application for a license was denied without giving Clemshaw an opportunity to be heard. Clear? Are the facts clear?
Yep.
Question. Was there a breach of the right to natural justice?
Well, no, because there is no legitimate expectation that they would receive their license.
Very good. And there is no right either. You cannot have a right to a license. Karina, did you want to say something?
No, I just wanted to say the same thing. That's all. My children were a little bit quiet, so I just.
Okay. So just pay attention to that particular scenario I gave. Keep that in mind in relation to the final assessment. That was a hint. Are you clear?
Okay.
Very
Thank you.
good. Okay. So do you still want to go to problem 5? We had a problem 4 in relation to a new license. Do you want to go? We've actually, the one about problem 4 really relates to an application for a job. And the person's application for employment was rejected without that person being given an opportunity to be heard. His application was simply rejected. The question is, a person applies for a position, for an employment position, and his application was rejected, meaning he wasn't accepted. Does that applicant have an expectation that he should have been given an opportunity to be heard? Meaning, would his right to natural justice be breached? Would an applicant for a jobs, would the right to natural justice of an applicant for a job be violated if his application is rejected without him being given an opportunity to be heard? So that is the legal issue. The legal issue is, let me repeat, would the right to natural justice of a person who applies for a position be violated if his application for a position or employment is rejected without him or her being given an opportunity to be heard? That is the legal issue. What do you think is the answer there?
There is no legitimate expectation that I will get a job.
Very good.
So therefore, Dr. Smith shouldn't have, he wouldn't have right to legitimate expectation to be successful in the job application. Therefore, there is no natural justice being breached.
Very good. There we go. Easy. Okay. Any questions before we end tonight's session?
I guess are we coming back to the quiz?
Okay, let's go back to the quiz.
I think we're going to come back to that before we finished.
Yes. So going back to the quiz. So let's just go back to the quiz questions. There are two. Should we go back to the facts again? There are two aspects of the facts here. One is that there is a claim that the minister showed a bias against the students who protested. And secondly, the other aspect is the minister did not provide a reason for the rejection of the application. So the point there being is there a requirement as part of the prior hearing rule that an executive who makes a decision must provide reasons for the decision, so that if no reasons are given, that is a breach of natural justice. That is the legal issue there. Do you know the answer?
Yep.
Do you know the answer to that? We probably did not discuss that. Let's assume in that. So the answer, the basic rule is that really, and without really answering that particular quiz, the principle is that there is no rule that a decision maker must provide reasons for a decision. So the right to natural justice includes the right to be heard and the right against bias, but the prior hearing rule does not contain a requirement that a decision maker must provide reasons for a decision. It does not exist. There is no such right. So the right to natural justice, or in particular the prior hearing rule, simply requires that before a person's rights, legitimate expectations, or interests are breached by the actions of an executive, that person must be given an opportunity to be heard. It is an opportunity to be heard. There is no requirement that an executive must provide reasons for a decision. Are we clear? So when you make an application and an application, for example, is made against you, and the minister or the executive does not provide the reasons for the decision, that is not a breach of the right to natural justice. Are we clear? However, if you follow Section 13 of the ADGR Act of 1977 Commonwealth, that particular provision does provide that an applicant who has a right to apply for judicial review may ask an executive to state the reasons for his decision. So when the right to judicial review is available, then a person may ask an executive to state the reasons for the decision. But the mere fact alone that a decision maker or an executive did not provide reasons or a reason for the decision does not mean that the right to natural justice has been violated. Because the right to natural justice does not include a right to be given reasons for the decision. There is no such requirement. Clear? And we know the rule about bias already. We discussed that. Okay. Any questions for tonight before we go? We're good. So thank you, Michael. Thank you, Karina, Harry, and Clinton for joining tonight's session and for engaging. And all the best in your midterm assessment. Okay.
Thank you.
Good night.
Thank you so much. Thank you so much.
Thank you. Bye.